Tonight on the Daily Debrief, he's accused of keeping a Wisconsin girl captive for 88 days. Today, he speaks in court.
Do you want a preliminary examination?
No.
Plus, closing arguments in the case of an admitted meth mommy facing murder charges over the death of her child. And a state high court issues its opinion on the conviction of Michelle Carter, the young woman who encouraged her boyfriend's suicide through text messages. This is the Daily Debrief for Wednesday, February 6th. Good evening, everybody. Aaron Keller along with Ronn Blitzer tonight. Welcome to the Debrief. A preliminary hearing today for the Wisconsin man accused of taking a girl and locking her up in his bedroom after murdering her parents. Jamie Claus disappeared on October 15th last year. Her father was gunned down at their front door. Her mother shot and killed in the family's bathroom. A frantic search for Jamie turned up nothing until January 10th, when Claus freed herself and approached neighbors near where she was held. She was captive for 88 consecutive days. The state says Jake Patterson admitted his role in the crimes. He's charged with 2 counts of first-degree intentional homicide, 1 count of kidnapping, and 1 count of burglary while being armed with a dangerous weapon. The defense, at the last second, waived his right to have a judge determine if there's enough evidence to head to trial.
This is the time schedule for preliminary examination. Mr. Glenn, you informed me that your client wishes to waive preliminary examination.
Your Honor, Mr. Patterson is prepared at this time to waive his right to a preliminary hearing.
Okay. Mr. Patterson, do you understand that you are charged with felonies and you're entitled to a preliminary examination if you want one?
Yes.
And you also may waive that. A preliminary examination is not a trial. Witnesses would be called by the state to testify against you, and you have the right to have your attorneys cross-examine them. You also have the right to present your own evidence. The purpose of a preliminary examination is to determine whether probable cause exists. Probable cause means facts together with reasonable inferences from those facts, which would lead a reasonable person to conclude that a felony has probably been committed and that you probably committed it. If the court finds there is probable cause to believe that you did commit a felony, you would be required to stand trial. If the court does not find probable cause, the charges would be dismissed or reduced, or the state may refile. Do you understand your right to a preliminary examination?
Yes, sir.
Do you want a preliminary examination?
No.
And do you understand the charges against you at this time?
Yes.
Have you had enough time to discuss the waiver of preliminary examination with your attorneys?
Yes.
Did anyone make any threats or promises to get you to waive this right to a preliminary examination?
No.
Senior legal editor here at Law&Crime and former prosecutor Ronn Blitzer joins me tonight on the Debrief. So, Ron, this was a bit of a surprise because usually when someone waives a preliminary examination, at least in Wisconsin, and I was there for 3 years, usually, if memory serves me properly, it's well before this stage. They don't wait for people to pile into the courtroom and presumably hear some evidence to turn around and say, oh, no, I don't need this.
Yeah, so it begs the question of what was the decision here between Patterson and his attorney, and whose decision was this ultimately, and how long it took to reach that decision? Because you look at what the attorney had said previously after the charges were first brought in the criminal complaint, where he acknowledged that there was quite a hurdle here given the descriptive confession that police said that Patterson gave to them upon arrest. So it's possible, in my opinion, that Patterson's attorney wanted to waive this for a while, but maybe Patterson himself wanted to go forward with a hearing at first and then ultimately decided at the last second, okay, we'll forgo this.
I did not at any point expect Jamie Claus herself to get up on the stand today because in Wisconsin, preliminary hearings can involve hearsay testimony. That's allowed at this stage in Wisconsin. It's a relatively new rule. I was expecting mostly police officers at least to get up there.
Yes, absolutely. There's definitely plenty of evidence to provide probable cause here, including Claus identifying Patterson as her captor. But like you said, you had plenty of police officers here. There was a detective who, in the complaint, attested to hearing from Patterson his whole plan, how he first saw Claus board a school bus, and then decided how he was going to commit the act.
And of course, the neighbors who helped her secure a safe spot in their home after she was able to get out of that situation. We will follow the case. Ron will check in with you again in a moment. Closing arguments today in that case of an admitted meth mommy accused of murdering her baby by neglecting him and leaving him to die. Let's run through the facts of this one last time here on the Debrief. Prosecutors say 4-month-old Zachary Cohen died in a child swing because his mother, Cheyanne Harris, and his father, Zachary Cohen, stopped feeding him and left him to rot in his own feces. The prosecution juxtaposed the concept of a child being a blessing with something else.
On May 1st, 2017, the defendant was given a blessing, a baby boy, a healthy, happy, innocent baby boy. Now that you have heard all of the evidence, it should be clear to you that the defendant didn't want the responsibility of that blessing, that she didn't accept the responsibility of that blessing, and that she let her blessing die a slow and painful and unnecessary death. And just as during Sterling's life, when the defendant took no responsibility for him, it's the same in his death. That's why we're here, because she doesn't take responsibility for his death. Actions and consequences, that's what this is about. You, as the jury, will soon be in the position to decide what her actions were and what are the consequences. Is it guilty? Is it not guilty?
Not long after that, the prosecution cut straight to the disgusting details of little Sterling's death.
You know, maybe some of you in the beginning of this case, when you heard maggots, you thought, well, he died and they left him in the swing for a long time, and that's why there's maggots. Well, you know now from the evidence that's not the case. Right? Dr. Klein said based on the Riger, Sterling could have been dead for up to 8 hours. Maybe a day. Because had he been dead longer, he would have looked differently. He would have been bloated. The Riger, he would have been stiff. It would have gone away by that point. Right? He had just died. Dr. Huntington talked about facultative myiasis, infestation of the living. And that's what he saw in this case. Had Sterling been dead for an extended period of time, there would have been blowfly infestation, not scuttlefly infestation. He also would have seen the flies in Sterling's nose and his ears and things like that. It would have looked different. So Dr. Huntington can tell you from the insects that he was only dead a half day to a day. And the entire rest of that time, he was alive, going through a painful, horrendous death while 2 adults were in another room. This was torture. This was cruel. There's absolutely no question.
The defense, meanwhile, made 2 arguments. One surrounded the facts, the other surrounded the law.
What is the difference between first-degree murder and child endangerment causing death? The argument that I heard is that they're one and the same. But that is not true. Iowa recognizes a distinction. We have a statute that says child endangerment causing death is a crime. We reserve the most infamous crime in the state of Iowa, first-degree murder, for the most violent acts, the most violent of people. We convict people of child endangerment causing death when they are negligent and willfully deprive them of care, which is exactly what happened in this case.
Next, the facts and an acceptance of guilt on one of the charges.
What's important is the idea that Ms. Harris is not taking responsibility. That is not true. She looks back on what was happening in that era and realizes I was really messed up. I was really messed up. And we are not disputing that. She was really messed up. And because she was really messed up, and because of the choices that she made, because she did willfully deprive Sterling of critical care, we are not arguing that. The facts of this case support a conviction for count 2. Read it. It's exactly what happened in this case. We accept responsibility for that conviction. That's what happened. When people know that they've done wrong, they like to feel that there's been a balance, that they pay for what the wrong that they did. We accept the conviction for count 2. The reason that we're here, and the reason that we've taken a week and a half out of your life is because it is not murder. The acceptance of responsibility requires, and Ms. Harris accepts, the conviction for child endangerment causing death. Justice, the finding of truth, requires the finding of not guilty for murder in the first degree, because there is no murder without malice.
During a rebuttal, the prosecution hit 2 key points. First, this defendant's other child was completely healthy. Second, that she was hiding her baby boy from the drug dealer who started a romantic relationship with her.
There's a happy, healthy baby girl in that house, while her baby boy lay rotting in the back room. Depression doesn't work that way. You don't pick and choose like that. Could it be because she didn't want him in the first place? Could be. Could it be her only care was pleasing Zach? Could be. Could it be that she wanted out of that apartment, she wanted back on the road with Zach and all, and Sterling was getting in the way of that? Could be. But the point is, it doesn't matter. All of those would be reasonable inferences, but the why doesn't matter. And does it change anything? Jordan Clark, he was in their apartment at least 2 times doing that with the defendant while Sterling was in the back room, and he had no idea they had a baby. And you could stay up for nights, for weeks, for months, trying to figure out how another human being can do this to a child. But you're never going to find yourself a good answer. And the only thing you're going to do is lose sleep. Okay? The why doesn't matter.
What the state did not do is spend much time, if any time, pointing to this key piece of testimony from the drug dealer who was doing meth with the defendant. It turned out Cheyanne Harris was also part of a budding new romance, in spite of the baby prosecutors say she was neglecting in the other room.
Have any type of romantic relationship with defendant Cheyanne Harris?
No.
After Sterling died, did you develop a relationship with her?
Yes.
How did that happen?
Just from texting back and forth, kind of. One thing led to another.
When did it happen?
Probably mid-September.
And was Ms. Harris still together with Mr. Cohen?
I believe so, yes.
Did you meet up with Cheyanne and have sex with her?
Yes.
More than once?
Yes.
Did Mr. Cohen know about it?
After the fact, yes, I believe so.
Did she make efforts to hide it from him before he found out?
I think so, yes.
How did he find out, Mr. Cohen?
I'm not sure.
After he found out, did he and Ms. Harris stay together?
I believe somewhat, yes.
Now, to be clear, your relationship with Ms. Harris continues to right now, right?
Yes.
How would you describe your current relationship with Ms. Harris?
Essentially the same as it was. Kind of much as it can be, I should say.
Now, you write and text her, right?
Correct.
Do you tell her in your writings and texts that you love her?
Yes.
Do you tell her that you want to be with her?
Yes.
Does she say that she loves you?
Yes.
That she wants to be with you?
Yes.
Do you exchange sexually explicit text messages with her?
And sustained.
Senior legal editor Ronn Blitzer, former prosecutor himself, still with me here on the debrief. So, Ron, look, this is my take on this. Seems to me that the state had a little bit more of a window that the state could have gone into to explain why one child was being cared for and the other one wasn't. And that window was, okay, there's this new relationship on the horizon. She doesn't want that guy to know that she's got a baby with the baby daddy, okay, who's been already convicted, because something's starting to go on here. And look, he said on the stand, oh, it just suddenly happened after the baby died. Does anybody buy that explanation? And could the state have gone further with that whole love triangle theory here?
The state very well could have gone down that road. I don't blame them for not. I mean, clearly they didn't have to. And I think that this would have really opened the door for a whole other line of questioning, and it could have confused the jury a little bit. There was so much evidence in this case against Cheyanne Harris that they didn't need to go anywhere else.
Interesting tactic. We see it from time to time where the defendant accepts guilt on a lesser charge, trying to dodge the top charge. And we saw that again here. That quote, I was really messed up. That's what her attorney says is going through her mind, even though she didn't take the stand.
Yeah, you see that a lot when there's so much evidence in a crime that's so horrifying, when there's so many details, where the defense just says, listen, no one's arguing that the result here was awful, but as far as the defendant is concerned, it's not as bad as the prosecution's saying they are.
Yeah, and of course some debate there about the law. The state saying that the law makes child endangerment into murder basically just by operation of law, as long as the baby dies. Otherwise, it's just simply child endangerment. Maybe the appeals court will have to straighten that out. If there's a conviction, we continue to watch and monitor for a verdict. Still ahead, though, tonight on the Daily Debrief. Are text messages enough to convict someone of involuntary manslaughter? The highest court in Massachusetts issues its opinion on Michelle Carter's conviction for repeatedly encouraging her boyfriend through text messages to kill himself. That report and more when the Debrief continues. Welcome back to the Debrief. A strange scheduling move in the case of the Michigan State University president accused of lying about her knowledge of a sex assault scandal. Luanna Simon is accused of a series of crimes related to her handling of the case of gymnastics doctor Larry Nassar. Testimony in this hearing is on hold until April 9th. Usually, preliminary hearings are done quickly over a short period. Here, though, the judge had to schedule a conclusion of the hearing for a date more than 2 months away. A Florida woman convicted of playing a role in her husband's death today received a mandatory life sentence. A jury convicted Denise Williams of conspiracy to commit murder, first-degree murder, and of being an accessory after the fact in the death of Mike Williams. A judge wiped out the accessory count because Brian Winchester was the actual triggerman. He was Mike's friend and Denise's eventual lover. Now to the case of the Southern California man accused of killing all 4 members of the McStay family. Charles Chase Merritt was a business associate to father and husband Joseph McStay. First, the McStays disappeared. Then, authorities believe they may have fled to Mexico to avoid debts. Police even pointed to video shot near the border as proof. Then the authorities backtracked when a dirt biker stumbled across the family's remains buried in the Mojave Desert. Prosecutors claim the defendant killed for money. Yesterday, without the jury present, the prosecution argued over testimony from a state analyst who enhanced security camera video from a neighbor's house. The enhancement shows what prosecutors are arguing is the defendant's truck in the neighborhood where the McStays lived around the time the family disappeared. The state believes the family was murdered at home. The defense does not want that video shown. Today, a QuickBooks customer representative testified via Skype that someone claiming to be Joseph McStay called to cancel his business's account after Joseph McStay disappeared. It's unclear who placed the call. The defense says another man besides the defendant had his hands on Joseph McStay's company's financials. That other man, named Dan Kavanaugh, is the defense's alternate suspect. The highest court in Massachusetts has affirmed the conviction of the young woman who encouraged her boyfriend's suicide via text messages and sometimes through phone calls. A judge convicted Michelle Carter of involuntary manslaughter for encouraging the suicide of Conrad Roy. Roy took his life after the two had talked about it many times over again. When he was on the fence, Michelle Carter pushed him to go on. The case drew national headlines over whether words alone could sustain a conviction. Carter chose to be tried by a judge alone and not a jury. Law&Crime's Ronn Blitzer read the Court of Appeals, or I should say the Supreme Judicial Court opinion in this case. He's back again one more time. So, Ron, explain the opinion. What does it do?
The opinion here from the Supreme Judicial Court really took a look at not all the evidence in the case here. It wasn't relitigating the matter here. It didn't go through all the facts, but it did examine the lower court's decision to convict Carter for this. And it was, as you said, it was a very controversial case because she was convicted of involuntary manslaughter when she wasn't the one who actually killed Roy. It was suicide. And there was a lot of debate over, whether or not this violated the First Amendment because she's being punished for her speech. And also, in my opinion, this was really tough because it was an involuntary manslaughter charge, even though her actions were clearly voluntary. But the High Court looked into this and said, no, there is precedent to back this up, citing a 1961 case where similarly a person was convicted of involuntary manslaughter for coaxing someone else into suicide. Now, in that case, it was a little bit different because it was a husband who placed a gun into his wife's hands and showed her how to best pull the trigger.
Providing some means there.
Exactly, but it was a similar principle which showed that even though the judge's decision in the lower court was controversial, there was reason for it and there was enough evidence behind it to uphold it.
Well, the law moves along with technology. The question now is what's going to happen in the federal courts. And look, I know we were back and forth on this quite a bit when we covered the original case here. The judge at the lower court level really bulletproofed his finding, really cited specifically why he was finding the way he did. And a lot of his opinions sort of tracked what the Supreme Judicial Court, the appeals courts, had already said because this went up the chain once before. And then it went down to trial, and now it's back up the chain. So we'll have to see if the federal courts weigh in. Ronn Blitzer, appreciate your opinions tonight.
Always a pleasure.
Thanks for watching The Debrief, ladies and gentlemen. I'll see you back here on The Debrief at either 4 o'clock or 5 o'clock on the Law&Crime Network. Our schedule here depends on testimony in the McStay family murder case. Live trial coverage resumes tomorrow at 9 o'clock Eastern and after this in the McStay family case.